Hello, and welcome to this video, which introduces the Massachusetts Environmental Policy Act program for the Commonwealth of Massachusetts. The MEPA program provides meaningful opportunities for public participation in the review of both public and private projects proposed in the Commonwealth. In this video, I'll spend about 10 minutes going over the basics of MEPA, including what MEPA is, when MEPA review is required for projects, and what happens during the MEPA review process. If you're interested in additional details about how you as a member of the public can participate in MEPA, I'll direct you to a separate video that's available on our website that was prepared by the MEPA Environmental Justice Liaison, Kate Arson. Thank you for your interest in the video. My name is Tori Kim. I'm the Assistant Secretary for the Executive Office for Energy and Environmental Affairs, and I'm the Director of the MEPA office. I welcome your interest, and I'm glad you're here. As I've indicated, this video will go over the basics of MEPA, what the MEPA program is, when MEPA review is required, and what happens during the review process. I'll also go over some specific environmental justice requirements that were incorporated into the MEPA review process as of January of 2022. The MEPA program is modeled on the federal program called MEPA, or National Environmental Policy Act. These statutes were enacted in the early 1970s to ensure that the environmental impacts of projects are reviewed before they are approved. About 16 other states have similar programs that are often referenced as mini MEPA. The principles of MEPA program are threefold. First and foremost, it ensures that an environmental review is conducted before a project is approved and at a time when project alternatives can still be considered and adopted. MEPA review is intended to be broad and in most cases will encompass all applicable environmental impacts that may flow from the project. And last, public participation is a critical component, and we seek to ensure meaningful opportunities for public review. As I've indicated, we've prepared a separate slide on how members of the public can participate in the MEPA review process, and that is available in a separate video available on our website. The purpose of MEPA is set out in the statute itself. However, I will go over some key aspects in this slide. First, the MEPA review ensures a review of environmental impacts and to ensure that projects make best efforts to avoid or minimize environmental harm. And if avoidance and minimization measures are not feasible, then to propose mitigation to the maximum extent practicable. As I've indicated, public participation is a key component, and MEPA seeks to ensure meaningful opportunities for public involvement to ensure that the public is involved in governmental decisions that may affect the environment. And lastly, MEPA seeks to coordinate agency review. As I will describe further in the next slide, the MEPA office does not directly approve or deny the project. However, because there may be multiple agencies that have various forms of approval or permitting authority, the MEPA review process affords opportunity to coordinate those reviews by the agencies involved. And the information that's gathered during the MEPA process will inform the actions that those agencies will take. So when is MEPA review required? There are two conditions that are required for a project to undergo the MEPA review process. First, as I indicated, some form of action is required by an agency. In most cases, that will be a state agency. However, certain municipal authorities, such as redevelopment authorities or housing authorities, may also qualify as agencies under MEPA. The forms of agency action that require MEPA review are varied, but could include the agency directly undertaking a project as the project proponent, or could also include various forms of approvals or permits by agencies that are required for projects proposed by third parties, and could also include funding and land transfers, such as easements or fee transfers that may be required. The fact that agency action is required for a project, however, is not sufficient to require the additional level of review through the MEPA process. The MEPA regulations at 301 CMR 11.03 set out certain levels of environmental impacts that are referenced as review thresholds that also dictate whether the project requires review. These review thresholds are organized into several categories of environmental impacts and include land, rare species, wetlands, water, wastewater, and other impacts that are listed in this slide. Agency promulgation of regulations that may decrease environmental protection may also be subject to MEPA review. So what happens during the MEPA review process? At its heart, MEPA review entails the review of environmental documentation related to the impacts of the project and the taking of public comments and the issuance of an ultimate decision called a certificate that's issued by the Secretary of Environmental Affairs upon the recommendation of the MEPA office. There are two general types of environmental documentation that undergoes MEPA review. The first is called the Environmental Notification Form, or ENF. This is the initial project filing that is submitted to the MEPA office. The ENF form is available on the MEPA website and also includes a list of required technical attachments, such as the project site plans, a mapping of the natural resource areas that are protected within that project area, and now environmental justice mapping, as well as a climate assessment. The ENF is published twice a month. The ENFs are published twice a month in an online publication called the Environmental Monitor. The link to the monitor is available on the MEPA website, and members of the public can also sign up for an email notification twice a month whenever the monitor is published. Public comments on the ENF are taken for 20 days, and the decision is issued within 10 days thereafter. The comment period on the ENF can be extended with the consent of the proponent. The certificate on the ENF will state whether further environmental review in the form of an EIR is required, which stands for Environmental Impact Report. And if an EIR is required, what must be included in that environmental documentation? And that's the second type of environmental report that I will go over next. As I've indicated, EIR stands for Environmental Impact Report, and it's a lengthier, more technical type of documentation that is required. There is no prescribed form for the EIR. However, the MEPA regulations set out detailed guidance about the sections and headings that must be included. The MEPA office also issues a variety of specific protocols and guidance documents in areas such as traffic and greenhouse gas emissions, and now environmental justice and climate resilience. The EIR is published, again, twice a month in that Environmental Monitor. Public comments are taken for 30 days, and the decision issued within 7 days thereafter. The comment period can be extended on the EIR. However, the final EIR that's submitted with the MEPA office cannot be extended. The decision on the EIR will state whether that EIR is adequate to meet MEPA regulatory requirements, and if not, whether additional EIRs are required. As of January 1, 2022, all projects that require MEPA review based on those two requirements that I went over earlier and are also proposed near environmental justice communities must now submit both of the environmental documentation listed here, both the initial project notification form as well as a mandatory EIR document. So in this slide, we've offered more of a pictorial depiction in the form of a flow chart that goes over in more of a step-by-step fashion what happened during the MEPA review process. As I indicated, all new projects filed with MEPA will file this ENF form, which undergoes that 20-day comment period with decisions issued within 10 days thereafter. At the conclusion of ENF review, the Secretary of EEA determines whether an EIR is required. In most cases, this will depend on two key factors. First is whether the project exceeds what's called mandatory EIR thresholds in MEPA regulations. As I described earlier, these review thresholds lay out levels of impacts that mandate the MEPA review process. The lower levels of impacts are called ENF thresholds, and that applies to all MEPA projects and dictates whether the filing of an ENF is required. However, higher levels of environmental impacts are covered by what's called mandatory EIR thresholds. And examples of this would be 10 acres of impervious area or 50 acres of all land alteration. And if those review thresholds are exceeded for the project, then mandatory EIR is required. As of January of 2022, as I indicated, we also look at whether the project is proposed near environmental justice populations, either 1 mile or 5 miles, if the project affects air quality. And if either of those factors are met, then mandatory EIR is needed. So if neither of these factors are implicated for the project, then in most cases, MEPA review will conclude at the end of the ENF review process. However, the Secretary of EEA always retains discretion to order a discretionary EIR. But if mandatory EIR thresholds are exceeded, or if the project is proposed within 1 or 5 miles of EJ populations, then it's now a mandatory EIR review. This EIR takes multiple forms in the standard process of draft, and subsequently a final EIR is submitted, each of which is subject to the 30-day comment period. In some cases, the proponent may request that a single EIR is submitted, in which case it's a single EIR review. There are also additional forms of streamlining, such as an EIR called a rollover, which is submitted together with the initial ENF filing. And if all requirements are met, that EIR is rolled over for an additional comment period. At the conclusion of EIR review, the Secretary ultimately determines whether that final EIR is adequate to comply with MEPA requirements. And if not, supplemental EIRs can also be required. However, if all requirements are met, then a final certificate is issued, and the project then continues to the next stages of approval. As I indicated earlier, the MEPA office does not ultimately approve or deny the project. And so the conclusion of MEPA review does not indicate approval for the project. It goes on to the next stages where other agencies that hold that ultimate approval authority will issue their final decisions. As I've indicated, the legislation passed in 2021 now imposed new requirements related to environmental justice that went into effect as of January 1, 2022. The key requirement is that mandatory EIR requirement that I've already described. However, the climate legislation called the Climate Roadmap Act also added new requirements related to public involvement and indicated that if an EJ population lacks English language proficiency in particular, then additional measures should be taken to enhance opportunities for public involvement. The Act required the Secretary of EEA to issue guidance on what additional measures are required. And I will note that under MEPA regulations, this outreach requirement was broadened to require a minimum level of outreach and public engagement activities for most projects proposed near environmental justice populations. And as I've indicated, that designated geographic area is at minimum 1 mile around the project boundary if environmental justice populations are located in that radius. However, if the project affects air quality, and that is defined in MEPA regulation, then that geographic area is increased to 5 miles. So that concludes the basics of MEPA process. In this final slide, we've also offered some project statistics that show the types and numbers of projects that have been filed with MEPA since the environmental justice requirements went into effect in 2022. So as is indicated at the bottom of the slide, in the period between January 1, 2022 and the end of 2024, a total of 410 new project filings were submitted with MEPA, and about over 50% of those projects were proposed near environmental justice populations and are subject to those new EJ protocols and regulations that I described earlier, including a mandatory EIR requirement. Consistent with past practice, the top category of the highest number of filings are in the real estate category, including commercial and residential projects. However, energy, infrastructure, and increasingly restoration and climate resiliency projects are also filed with MEPA. So that concludes my presentation on the basics of the MEPA review process. If you have additional questions, the contacts for the MEPA office are available on the MEPA website, and that now includes our new environmental justice liaison, Kate Harson, who can be contacted at the email address indicated on this slide. Again, I very much welcome your interest in the MEPA review program, and I look forward to your participation in our MEPA reviews. Thank you.